Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. The first case on our docket today is advisory opinion to the Attorney General Ray adult use of marijuana. Counsel, you may proceed.
Good morning, Mr. Chief Justice, and may it please the court. We're here today on the Attorney General's petition for an advisory opinion on the citizen initiative entitled Adult Use of Marijuana. My name is Amit Agrawal, and I'll be presenting argument on behalf of the Office of the Attorney General. We'll next hear from three other opponents of ballot placement, after that from the sponsor, and then a brief rebuttal from two of the opponents. The parties have collectively raised a broad range of issues in multiple rounds of briefing to the court. And to avoid duplication, and if it's agreeable to the court, I'd like to go straight to the heart of the Attorney General's submission to this court, and that is to the accuracy of the ballot language. Florida law gives voters a right to vote on citizen initiatives that would amend their constitution. And this court has traditionally been reluctant to interfere with the exercise of that right, and properly so. However, as this court has repeatedly stressed, that right and the initiative process itself are subverted rather than protected when ballot language includes a misleading summary. And we think that that's the case here. The ballot summary tells voters that the proposed amendment, quote, permits the possession, use, purchase, and sale of marijuana. The problem is that if the proposed constitutional amendment were adopted, it would not permit those things. It's undisputed that federal law makes it a crime to possess, use, purchase, or sell marijuana, and the proposed amendment would not either undo or override that federal law. Because the ballot summary tells voters that it would permit something that it would not permit, the language is affirmatively misleading. Now,
I'm sorry to interrupt you.
Counsel, what would you say to the argument that an amendment to the state constitution should naturally be understood as affecting state law and not affecting federal law?
Your Honor, that argument might carry more force if we were talking about how a court should construe a legal document that's directed at legal professionals. And one of the big problems here is we're not talking about the text of the proposed amendment itself. We're talking about a ballot summary that's going to be read not by lawyers who are learned in the law, but instead by ordinary voters. And our bottom line position is we think that voters have a right to assume that the ballot language means what it says. And that's true not just on the basis of the general meaning of the word permit and the unqualified use of that word in this particular ballot language, but it's also true because of at least four context-specific and case-specific considerations that we think should inform the court's analysis.
I'm sorry to interrupt you. Before you get to the 4 points, let me just ask you a quick question though. So if we're looking at it from a kind of ordinary voter's understanding, medical marijuana is equally illegal under federal law, right?
That's right.
So in my 5-minute drive to work, I think I passed like 10 medical marijuana dispensaries that are there and operating because of the previous constitutional amendment. Why wouldn't a voter, you know, if this were to become part of the Constitution, obviously we don't have a crystal ball. We don't know if federal enforcement policy would change or whatever. But in terms of just sort of the real world sort of common sense understanding of voters, why wouldn't this have the same kind of an effect?
Your Honor, it's a really important question, and I'm glad that you raised that issue because this court in 2015 approved for ballot placement a medical marijuana amendment to which Your Honor refers, and the text of that amendment included two critical qualifications. One is that that amendment would not immunize violations of federal law, and second, that the amendment applied only to Florida law, and therefore it put voters on notice that as a practical matter, if you engage in this conduct, we're not saying that you wouldn't be subject to potentially catastrophic criminal liability. And we think the key point here is not how federal law would be enforced, because as Your Honor points out, we don't know what the content of federal law is going to be in the future. We don't know how it's going to be enforced. The key point is that voters should be told the truth, and they should be given the tools that they need to make a fully informed decision on this ballot initiative. And voters right now are told expressly and unqualifiedly that the proposed amendment would permit something that it quite simply would not permit, in the sense that it's undisputed that it could still subject the average person that Your Honor is talking about who's driving down the street. They could engage in certain activities that are enumerated in the text of the ballot summary. And like we said, they could be subject to federal criminal liability. And as we understand it, that's not in dispute.
And should we, in terms of, since it seems like you guys are placing all of your eggs in the permits basket, it seems like at least one of the other opponents I noticed characterized this as a problem with not so much what it says as what the summary doesn't say. You say that it's actually affirmatively misleading. I mean, which one of you is right about that? Because it seems like the failure to educate people about what people might think, what we would expect them to know about federal law is kind of a different type of argument than saying, but when I tell the voters permit, that I'm falsely telling them that there are no federal law consequences, which seems like that's more what you're arguing.
Yeah, so Your Honor is right, and two responses to that question. First, it is our position that the big problem with the ballot language is not what's not in it, it's what's in it. It's the fact that it expressly and unqualifiedly says to voters that this conduct is going to be permitted, even though it would remain a violation of federal criminal law. But I would respectfully disagree with Your Honor's characterization of us hanging our hat exclusively on the meaning of the word permit, because we do think that there are some very important context-specific and even case-specific considerations here that ought to inform the court's analysis. And if I could just briefly discuss some of those. One is that we know that there is potential for a whole lot of confusion about the interplay between state and federal law in this particular context, and that's the context of marijuana law and policy. In another ballot proceeding that is currently pending before this court, the Regulate Marijuana Initiative, the sponsor itself recently filed a brief with this court representing that the point of that proposed amendment is an attempted, quote, act of nullification of federal law. And on top of that, you've got overlapping federal, state, and local jurisdiction. You've got rapidly evolving laws. You've got changing federal enforcement policies. Sometimes the federal government seemed to be indicating that it wasn't enforcing the Federal Controlled Substances Act in jurisdictions which had legalized the use of marijuana under local law. And you've got widespread use of confusing and inaccurate language about purported legalization. So
what is confusing about the fact that it is illegal under federal law, and this makes it legal under state law? I mean, you seem to be doing, as one of my old colleagues used to say, the talk about what's confusing about federal law, and you're going into all these other details, but the facts are really simple. It is illegal to possess marijuana under federal law. This constitutional amendment makes it legal in Florida, but it's still illegal in federal law. That's the bottom line. And, are we not giving citizens some credit here for doing their homework? I mean, it is in the text under Florida law. It's just missing in the summary. But aren't we, it is under our system of justice, the old saying that ignorance is no defense, ignorance of the law is no defense. We have to accept that premise for our system to work. Can't we do the same thing here? We have to assume that people would have read the text, did their homework, read papers, read articles, and went in as an informed citizen to vote. Don't we have to accept that premise as well here?
Your Honor, we certainly have no quarrel with the premise that ignorance of the law is no excuse for violating the law. But this court has never said that that's an excuse for providing voters with affirmatively misleading ballot language. And Your Honor raises a really, really important point, and that is here, the sponsor cannot credibly argue that it's not important to include this qualification about limited to Florida law, because the sponsor itself chose to expressly and repeatedly include that critical limitation in the text of the proposed amendment.
Are you claiming that the text of the proposed amendment is misleading?
No, we're not. We're saying that Your Honor's point about this doesn't have to be complicated is exactly right. And the sponsor told us how we could make this not complicated. And that is to replicate in the ballot summary the precise language that's used in the text of the sponsor proposed amendment.
The precise language you're claiming is missing from the summary is included in at least 2 places in the text of the statute. So if we're to assume that citizens are educating themselves going into this ballot box, we should assume that premise that they read the text and studied it and know exactly what we're talking about. Illegal federally, legal in Florida. But can't we accept that premise?
But Your Honor, I don't understand this court's precedents to stand for the proposition that it's okay for ballot language to be misleading and to omit critical qualifications if voters could go read the full text of the proposed amendment and if they could then understand that the ballot language does not really mean what it says and it's subject to all kinds of limitations and qualifications that are not in the ballot language itself. Because
Counsel, could I ask you a question about something completely different? Because I know your time is running short. You have in your supplemental.
Its time has concluded. You can proceed.
Okay, I'll save it for. I want you to have some time left for a rebuttal, so we're good.
All right, and although your time has been exhausted, plus another minute, I will nonetheless afford you 2 minutes for rebuttal.
Thank you very much, Mr. Chief Justice.
Thank you. Counsel, you may proceed.
Apologize, Your Honor. My name is Jeremiah Hawks, and I am representing the Florida Senate today. The first question I want to bring up is the matter of the court's jurisdiction. You know, what the Constitution says is that when an initiative is going to qualify for the ballot, it has to get 8% of the number of people who voted in the last preceding presidential election. And what the legislature has said is you have to get 10% of that number previously, and now the statute's changed to 25% of that number. You have to get 25% of that number in order to get court review. And so what we have here, and so clearly those two things are tied together. The legislature meant for the same thresholds to apply to the court's review that apply to obtaining the ballot. And so what's happened here is this is clearly not going to be on the 2020 ballot. And in 2020, we're going to have a presidential election. And the threshold is going to change, barring the exact same number of voters voting in the 2020 election that voted in the 2016 election. And so we don't know what those thresholds are. And in the absence of that knowledge, I think it would be appropriate for the court to remand this back to the Secretary of State to be recertified when the new thresholds are established, and so that any initiatives that meet the new thresholds can be certified to the court at that point in time. I think that's the clear import of the constitutional language, and that's what the legislature intended to have happen. You know, what they wanted to do is show that there was a serious commitment on the behalf of sponsors to proceed, and they wanted to keep the court's review into the same context as obtaining the ballot. What the Attorney General has suggested is that once the court receives jurisdiction, the jurisdiction remains no matter what changes in circumstances may occur. And I would suggest that that's an error. The Attorney General says, you know, if the signatures expire, if the legislature changes the standards, if it becomes clear it's not going to make the ballot, none of those things can have any impact on whether or not the court should review. And I believe that that is incorrect. That is not supported by the text of the Constitution. The other point on that matter, Your Honor, is the Attorney General also makes reference to past practice. And I think there's two problems with this past practice argument. The first problem is as the Attorney General acknowledges in their brief, the court has never spoken to this issue. It apparently has never been brought up. And secondly, Your Honor, I don't believe it truly is a past practice. I mean, you're looking over past initiatives, and I cannot claim to have done an absolutely exhaustive review. but there are a number of examples where things have come up in election years, and what generally seems to happen is either the court rules prior to it becoming clear that the initiative cannot make the ballot, or the matter gets.
Counsel, let me ask you this: in cases such as that, what should we go back and invalidate our opinion?
No, no one's asking the court to go back and invalidate the opinion. I think that what happens.
Well, so your view: if we've issued an opinion, the ship has sailed.
If we issued an opinion, I believe the ship has sailed. The legislature has not asked the court to review.
What about the perspective that once the Attorney General has submitted the letter to us requesting an advisory opinion, that at that point the ship has sailed?
I don't think that that's what the legislature intended, Your Honor. And I think what that does is it deprives the legislature of the ability to do what they did this session. This session, the legislature said, you know what? We don't think that the standard of review has been working, and we think that we need to up the criteria. So I think to do that, Your Honor, in matters where it is clear that it is not going to make the next ballot, it forecloses the legislature being able to act for the court to step in and say, well, we're going to decide the matter anyhow. I mean, I don't think, jurisdiction is not a matter of convenience. It needs to follow the law. And in this instance, this matter should wait.
Well, the Constitution says that the court shall, when requested by the Attorney General, pursuant to the provisions of Article 10, Section 10, Article 4, render an advisory opinion of the justices addressing issues as provided by general law.
As provided by general law is what's key in that phrase, Your Honor. The legislature has said you'll do that when they have 10% of the signatures that they're going to need. And at this point in time, well, 25% of the signatures are going to need. And at this point in time, we don't know how many signatures are going to be needed for these various initiatives. And
Counsel, can I ask you a separate question?
Yes, Your Honor.
On the issue of the change to the law that now says that the court is supposed to look at the potential facial invalidity of the measure in relation to the U.S. Constitution, what is your position on what the remedy should be, assuming that the court were to, in this case or in some future case, if we were to address a question like that, what should the remedy be if the court thinks that it would be facially unconstitutional?
Well, as we addressed in our brief, there are a number of cases that say if a matter is facially unconstitutional, that the citizens do not have the power to amend their constitution in a way that violates the U.S. Constitution. And I'm not sure if the cases are, so there was a lot going on in those cases. First of all, those weren't advisory opinion cases. And second of all, there's an assumption in those cases that it would be futile for the voters to amend the Constitution under those circumstances. But I don't know if that really takes account of the possibility of the revive. So first of all, there's the issue of, I think that those cases those are based on predated the initiative process and the fact that the Constitution talks about, the one single subject requirement as being the only, at least on the face of the Constitution, the only requirement. But even if you accept the idea that, that this federal constitutionality is lurking in the background there, you still have the possibility of a revival of something in the Florida Constitution if federal constitutional law were to change, which, as we know, that's kind of a constantly moving target. So if the people of Florida want to put something in our Constitution that at a certain point in time might be unconstitutional, obviously subject to change, why does the legislature have the authority to restrict their ability to do that? Well, I don't think that they are putting this in the Constitution subject to future change. I think that they are putting this
subject to the change in federal law.
Subject to the change in federal law. I don't think that they are doing it subject to the change in federal law. I think they expect it to be implemented immediately. And what we've talked about, what Mr. Agarwal talked about, is the voters understanding what they're voting on. And if we're putting something in the Constitution that is unconstitutional, and at some random moment in time, some act of Congress is going to change our Constitution, I don't think we put things in the law
Well, I
the
mean, it could-
Constitution that are conditional like that, Your Honor.
So it could be, sorry to interrupt you, it could be a U.S. Supreme Court decision. But again, that really, you're sort of jumping from the idea of us, the Constitution doesn't say what these advisory opinions are supposed to do. Obviously, as a matter of practice, when we've been dealing with the 10161 issues and the single subject issues, where the court has said the requirements aren't met, the court has then said, okay, the amendment needs to be stricken from the ballot. That's something that the court just kind of decided. Could we read what the legislature is doing here as a true advisory opinion? The voters know what the court's view as to the possible constitutionality is, and then they can go ahead and do what they want, as opposed to the legislature adding a new substantive limitation on what the voters are allowed to consider at all in the Constitution.
I think, Your Honor, that putting in front of the voters a nullity is not what the citizen initiative process is for. And I do not, and I think what those cases say, and there's even one from the 1970s, the citizens cannot amend their constitution in a way that defies the U.S. Constitution. And I think that has to be the correct rule. I don't think, Your Honor, that we can amend our Constitution on a conditional basis. If this happens, then this will happen. And I don't think, Your Honor, that it is fair to voters to put a question in front of them. And this may take effect at some point in the future based on the independent actions of some third actor. We don't know when, we don't know who, maybe the Attorney General will
So do you consider this a legislative, what's the source of the legislature's authority to add a new requirement to what the Constitution says is a permissible subject of amendment?
I don't believe, I think that, what this court has always held, and I think is the correct holding, is that it is an implicit restriction that Florida constitutional amendments cannot violate the U.S. Constitution. You don't have to say that expressly. That's how the federal system works. And I think the court's focus only on the express limitation has ignored a very important consideration that I think the court should have been taking into account all along. And I think what happened in the term limits case, where you have the voters vote on something, and then you yank it out of the Constitution a few years later, I do not think that is fair to the voters. I do not think that is good for our Constitution, to put things in there that we know are never going to have any effect, and then just take them out later on. I think that these initiatives, we have to speak to the moment in time. When is the election occurring? What is the state of the law at that point in time? I mean, we may make all sorts of changes in the future. We have to look at the laws that exist right now. And I do not think it is fair to the voters to do that. And it also...
Counsel, your time has been more than exhausted, but I will also afford you 2 minutes for rebuttal.
Thank you, Your Honor.
All right. Counsel, you may proceed.
Thank you, Mr. Chief Justice. May it please the court. Excuse me. My name is Jeremy Bailey of Weber, Crabbe & Wien on behalf of the Drug Free America Foundation, the Florida Coalition Alliance, National Families in Action, and Smart Approaches to Marijuana, collectively the drug-free opponents. I don't want to duplicate any of the arguments the court has heard or will hear. I want to focus specifically on an argument that was addressed in our briefing, the fact that the ballot summary hides from voters and is therefore fatally defective this broad grant of immunity that would allow any adult to use marijuana or marijuana accessories in the state of Florida. In order to understand these provisions, I think going to the text of it itself is the best place to start. Section 1B of the proposed amendment in the public policy section states that an adult can possess, use, display, purchase, or transport marijuana or marijuana accessories, and then finishes by saying it is not subject to criminal or civil liability or sanctions under Florida law. Of course, the proposed amendment wasn't being drafted on a clean slate. It was doing so in light of what had happened in Marijuana 2 and in Marijuana 1. And even beginning back in Marijuana 1, the court, even though it put the initiative on the ballot, the Justice, Your Honors, Justice POLSTON and Justice Kennedy did address this or a similar immunity provision, and that it potentially allowed use of marijuana in accordance with the constitutional provision while still allowing harm or still causing harm, and then that activity being immunized. Fast forward to Marijuana 2, and I think that's the critical analysis here. The drafters of the amendment in Marijuana 2 actually corrected many of the issues that were noted in the dissents. Specifically including relevant here was the limitation section, subsection C, subsection 8, that stated that the amendment did not affect or repeal two types of claims: laws relating to negligence or professional negligence for 5 categories of people: qualified caregivers, qualified patients, caregivers, physicians, MMTCs, or their agents or employees. So it was essentially the same immunity with this clawback that allowed it to stay within the goalpost that the dissents had addressed. So you have this immunity for use, notably the 5 categories of people were the only 5 categories of people allowed to use marijuana in the medical marijuana scheme, and it clawed back any immunity for claims of negligence or professional negligence. Moving to the proposed amendment today, there is no such clawback. There's this broad grant of immunity to any adult, which is defined as any person over the age of 21, for use of marijuana or marijuana accessories, and it's open-ended for civil immunity under Florida law. The attempt to save that provision or to keep it within the goalpost is to point back to the subsection C, subsection 8 of marijuana 2, which is now enshrined in the Florida Constitution at Article 10, Section 29C8. But it's really comparing apples to oranges, and it doesn't, in fact, save the provision. You're talking about immunity for any adult in the proposed amendment, and then in the clawback, it's only talking about clawing back that immunity for those 5 categories of people. Just based on the plain text, there are individuals who are getting immunity under the public policy section that it would not be clawed back under subsection C, subsection 8. On that basis alone, in addition to the arguments that this court has heard regarding the text, the ballot summary is fatally defective because it doesn't give any notice to voters that they're allowing this immunity provision into the Florida Constitution. Certainly voters are going to have an understanding when they check yes in the box that some level of decriminalization is going to follow. That's going to be understood. But there's no notice to voters in this summary that immunity is also going to be given. The supporters of the initiative have argued that it simply gives the same amount of immunity that any other product enjoys under Florida law. But there's no other example where we've enshrined in our Florida Constitution immunity for the use of any particular product, specifically not a hallucinogen. I think this court's precedents are clear that a ballot summary can be misleading by omission, just as if it was affirmatively misleading. So the fact that this ballot summary is completely devoid of any reference to this immunity, but has this broad immunity granted in it, renders the summary.
Let me ask you a question. Do you agree that if we were going to prohibit the voters from amending their constitution, that it should be, based on omission, that it should be a material omission? I mean,
yes, Your Honor, it should be a material omission.
And what do you think material means in this context?
So something that the average voter wouldn't understand that was coming along with this proposal. So the difference between someone voting.
Wouldn't material mean that would make a difference in their vote?
I think that's part of it, but I think part of it is going to.
There's a lot that you can't explain that people wouldn't know in a very short 75-word summary that's supposed to only hit the chief purpose, right?
Yes, Your Honor. But I think when you have an understanding for voters that they're going in with this expectation of decriminalization, when you have hidden in the amendment this civil liability immunity, that is material. They're essentially broadening what they're saying they're allowing. They're not just permitting the use of marijuana, they're immunizing the use of marijuana. And that's a difference that I think is a material difference that should be reflected.
You think that whatever percentage of the voters have decided that they're for this would decide they're not for this if they only knew what you're talking about now?
I think some voters that may be an issue for some voters, Your Honor, but I think the most important thing is based on this court's decisions that the ballot summary must be accurate. The potential for a misleading ballot summary to convince people on the fence to vote for something that they may not otherwise vote for, I think is potentially difficult here. When you have voters not being aware or made aware that this civil liability immunity is buried in the text, and there's no notice whatsoever of it in the actual summary that voters are going to be basing their decision on. I think that large omission renders the ballot summary fatally defective, and this court should not permit this to appear on the ballot. Thank you, Your Honors.
Can I ask you, I don't understand your argument though. What's the immunity that you're saying is buried in the text? Because even though the text refers to sub 8 of the medical marijuana amendment, I mean, it doesn't seem like it even has anything to do with this.
Correct, Your Honor. So, and I apologize, let me see if I can be a little more clear. So in the proposed amendment in paragraph B1, it states that any adult is permitted to use, possess, use, display, purchase, or transport marijuana or marijuana accessories. Of course, marijuana accessories is any piece of equipment that's to be used to use marijuana.
Okay, hold on. And that's almost verbatim in the summary, right?
Correct.
Okay, so what is it that's not disclosed?
The last sentence of that and is not subject to criminal or civil liability under Florida law. So that is not subject to civil liability under Florida law is nowhere found in the summary.
I mean, isn't that kind of implicit in permits?
Not for civil liability, no, for criminal liability. And I guess that's the essence of my argument, Your Honor, that it's implicit that permit would allow decriminalization, but it would not say that you have civil immunity in a tort action for use of marijuana or marijuana accessories. I think that's the contrast here, that certainly voters are going to be expected to understand when they're voting to permit marijuana, they're voting to decriminalize under Florida law a substance. They're not going to understand that they're voting to have civil immunity under Florida law for the use of that same substance.
All right, counsel, you have exhausted all your time. If you want to sum up in 15 seconds, I will let you do that.
Thank you, Your Honors. Nothing further.
Thank you. Counsel, you may proceed. You need to.
Am I unmuted?
You are.
Okay. May it please the court, Jason Gonzalez with the Schutz & Bowen Law Firm representing the Florida Chamber of Commerce, Floridians Against Recreational Marijuana, Save Our Society from Drugs, and the National Drug-Free Workplace Alliance. Your Honors, just to illustrate how defectively misleading the first two sentences of this ballot summary are, if I was to turn to a Florida voter and tell them, if you vote for this amendment and it passes, if you're 21 years old, you will be permitted to possess and use 2.5 ounces of marijuana for any reason, recreational or otherwise. If I was to say that without any condition or qualification to someone, what would I be doing? I would be lying, because that is a patently false statement. If I had a client come to me as an attorney and asked me to give them an opinion regarding what the text of this proposed amendment would actually do if passed, if that was my advice I gave to my client, and then I went on to the second sentence of this ballot summary and said the same thing, that a medical marijuana treatment center will be permitted to sell marijuana for recreational purposes. If I said that with no condition, I would be committing professional malpractice. I would be violating the oath of attorney and the rules of professional conduct, because it's patently false, and it would not just merely be a mild misstatement. It would be a pretty serious misrepresentation, particularly with respect to saying unequivocally that you'll be permitted, or some entity will be permitted in Florida to sell recreational marijuana, because we know the sale of any amount of marijuana is not merely a federal crime, it is a federal felony punishable by 10 years in prison. So these are serious defects in those first two sentences. But there's another aspect to the first sentence that is uniquely misleading. And this actually is similar to a question asked in the February oral arguments on another amendment, when the Chief Justice asked about a part of a ballot summary that said a proposed amendment would provide regulation for limited use. But when you went over to the text of that proposed amendment, there was no limitation to the amount of marijuana that could be used. Back in this initiative, it is an even more misleading defect of a similar nature, because the first sentence of this ballot summary unequivocally says, permits use of up to 2.5 ounces of marijuana, up to 2.5 ounces of marijuana. Go to the text of the amendment. There is absolutely no limitation on the amount of marijuana you can use. That is affirmatively misleading. Now, I would like to make one comment on something that the Senate had argued in their brief. With my remaining time, the single subject argument that the Senate made, and I understand maybe this is not the case that you address a single subject defect because the misleading nature of this ballot summary is so obviously apparent. But the single subject argument made by the Senate is that subsections B1 and B2 are separate, disparate subjects that have been log rolled together in violation of the single subject rule in the Constitution and the court's log rolling precedent. And B1 is the decriminalization for personal use. B2 is a separate and distinct subject that leads to the proliferation of commercial sale by a certain type of entity called a medical marijuana treatment center, and it provides civil and criminal immunity to that particular type of entity. Those are two different subjects. And back in February in oral arguments that I watched, Justice Lawson had a very good question that he asked about a similar two proposals in one amendment, and he had some skepticism that that was log rolling when he asked why would a voter favor the decriminalization of personal use without also favoring some type of civil and criminal immunity for some entity to engage in the commercial sale. That's a very good question. And what I would say in response to that question is that there are actually a lot of people, I know a lot of them, that have a strong personal belief that they don't care what someone else does in the privacy of their home and puts in their body in the privacy of their home, but they don't, and they also don't want their tax money spent on criminal prosecutions for what's done in the privacy of their home. But there are many of those same people that may not want their children to see a commercial recreational medical marijuana or recreational marijuana storefront on every corner of their neighborhood. As Justice Muniz mentioned, and as in my neighborhood, if I send my teenagers to the closest Publix pharmacy, they're going to pass 3 of these medical marijuana retailers. And if there's a commercial proliferation for recreational marijuana, that is only going to expand. So there are a lot of people who oppose that, but this other proposal for just the decriminalization under state law only of the possession and use and transport by an individual in the privacy of their home, they may favor that. So I think those are all rolled together.
I'm sorry to interrupt you, and I understand what you're saying. If we were writing on a blank slate, I very much would appreciate that argument. But given that so much of our case law seems to be driven by this idea of if the components of an amendment are part of a kind of rationally connected plan, that we have tended to say that satisfies single subject. I mean, it seems like if that's the test, and maybe your argument is that we've gone astray by making that the test, but it seems like if that's the test, it would be hard to argue that linking those two things in this amendment wouldn't satisfy it.
Yes, and I think you're alluding to this judicially created, extra-textual, logical and natural oneness of purpose standard. Of course, the word purpose is different than the word subject. They have different meanings. And again, that was a judicially created standard that Justice Kogan says has caused as many questions and confusion as it's done to help the analysis. So again, I don't know if this is the case. You're going to even need to get to the single subject defects, but hopefully at some point, the jurisprudence of the court will get away from that standard, go back to the text of what is a highly restrictive single subject requirement in Article 11, Section 3. And this hasn't been discussed in any of the arguments on any of the amendments, but this is a highly restrictive single subject requirement, shall embrace but one subject and matter directly connected therewith, only that matter directly connected therewith, not any matter or something somewhat connected or indirectly. And many don't understand or don't know the history that when we first put a citizen initiative amendment process into our Constitution in 1968, there was no single subject restriction. The people came back 4 years later in 1972 and overwhelmingly adopted and added a highly restrictive single subject requirement because they realized after this went in 1968 that this is the one way out of the 4 ways we can amend our Constitution where the proposals don't go through any representative deliberative body like the Constitutional Revision Commission committees or the legislature or a constitutional convention, where you have people studying what will be the effect of different subjects all being put together and put in front of the voters. With a citizen initiative, somebody can draft it at their kitchen table, get the signatures, and get it on the ballot. And so the people came back and wanted to limit it to one discrete subject and only that matter directly connected therewith.
Council, you're now about a minute over, so you can sum up in 15 seconds.
I am. Thank you, Your Honors. We appreciate you making yourselves available in this format under these circumstances to give us a hearing. Thank you.
Thank you. Council, you may proceed.
Good morning, Your Honor. My name is George LEVESQUE. My co-counsel and I, Ashley Lucas, represent Make It Legal Florida. We're here on behalf of Petition Initiative 1911, titled Adult Use of Marijuana. And we're here to argue that the proposed amendment strictly complies with the requirements of 101.161 and Article 11, Section 3. The ballot title, using 4 words, describes the nature of the amendment: adult use of marijuana. And then in 75 words, using clear and unambiguous language, explains the chief purpose of the amendment: to permit adults 21 years and older to obtain limited quantities of marijuana for any reason. It piggybacks because an adult possessing marijuana needs to be able to obtain it somehow lawfully. It piggybacks off of the existing medical marijuana structure and allows medical marijuana treatment centers to provide marijuana to adults for their use. We disagree.
I'm going to interrupt you. Can I ask you about that? So the previous amendment on medical marijuana seems to have placed an affirmative obligation on the state to make sure that they provide for the availability of medical marijuana. And you can understand, given the public debate on that, why the voters would have wanted, it wasn't just sort of a passive live and let live type thing. It's an affirmative, we want to ensure the availability of this. By sort of bootstrapping your amendment, by including that into yours, it seems like you're incorporating a concept that you could see reasonable voters not necessarily being on board with, of wanting recreational marijuana to be available and affirmatively required to be available to the same extent as medical marijuana. And yet I don't know that a typical voter would have any clue that that's actually what's going on. Could you address that?
Sure. I think the amendment broadly is aiming to make available to the public, adults with restrictions that protect children, marijuana in some form or fashion. We piggyback off of the existing system. However, we don't describe a lot of the limitations that any policymaking body might engage in. We leave that to the legislature, and there's express language that would allow the legislature some room to operate if there are concerns with those things. But what we try to do is make it clear that Florida is no longer going to criminalize the adult possession of marijuana that's consistent with the amendment that we're proposing.
But it seems like by linking the two things together, obviously the medical marijuana amendment constrained the discretion of the Department of Health and or the legislature in a way that is significantly different from the discretion they would have, in the ordinary sense. And now you're kind of limiting, by incorporating that in here, you're limiting the departments and the legislature's discretion in the same way, and you're imposing an affirmative obligation to make recreational marijuana widely available that isn't disclosed. I mean, that's the problem that I'm asking about.
Sure. And to be clear, there's nothing that requires a medical marijuana treatment center in the law to provide to an adult. If there are medical marijuana treatment centers that want to focus on a medical only model and not engage in these activities, they're certainly free to. But at some level, an adult, and we believe this relates to the oneness of purpose, at some level, if you're going to decriminalize the substance, it makes sense to link that decriminalization with the ability to obtain it from somebody lawfully. And that's what we're doing here.
Okay, can I ask you another question? So in 2020, earlier this year, we said that ballot language can be clearly and conclusively defective if it fails to inform the voters of the material effects of the amendment. And let's assume we meant material legal effects of the amendment. And then in a separate case, Wiley, we said that issuing regulations is a legislative function. Your ballot summary doesn't make any mention of the fact that you're giving legislative power essentially to an executive agency with constitutionally restricted oversight by the legislature. How is that not a legally material effect of this amendment?
Going back to marijuana 1 and marijuana 2, the two prior cases from this court, I don't believe that was disclosed in those amendments.
It actually, in marijuana 2, it was. The ballot summary said the Department of Health shall register and regulate centers that produce and distribute blah, blah, blah. So it was explicitly disclosed.
Sure, and in this instance, we haven't created any new regulatory ability other than the existing constitutional structure that was created. So at least in terms of the savings language that was in the amendment, that it specifically addresses the legislature's authority to enact laws not inconsistent with it. That's the language that we have in ours. That's the language that was in theirs. And while their amendment discloses that regulatory authority, that's existing authority that our amendment technically doesn't touch. All we're doing is...
No, but my question goes to the fact that your amendment affirmatively gives regulatory authority to the department. Obviously, this is a dramatic, the whole idea of giving agencies constitutionally derived regulatory authority that's in some sense independent of the legislature is a dramatic departure from the legal norm. That was disclosed, at least to some extent, in medical marijuana 2. Your ballot summary here is completely silent on it. And so it seems like if you accept the premise that this material legal effects test is part of what the ballot summary law requires, it seems hard to say that you've complied with that by omitting any reference to that here. So do you disagree with the test, or do you disagree with the idea that it would be a material legal effect?
I think the concept of a material legal effect is about as amorphous as some of the prior tests that were applied by the court.
You think that's more amorphous than chief purpose?
I believe the text of the statute talks about the chief purpose. I think the material legal effects could be broader, where an amendment has a lot of different effects, all of them being equal. When you're confined to 75 words, I think you have to be a little more flexible and understand that the chief purpose is clearly articulated in this amendment.
Okay, so in your case, how did you decide you have your first two sentences. One is the decriminalization for the use and possession, and then the second sentence goes to the distribution and sale. Is that one purpose or two? And if there are two, which one is the chief purpose?
The chief purpose is the first sentence.
So everything else after that was gratuitous?
Everything after that was explaining additionally the chief purpose, how the chief purpose will work, because it's not simply stating the chief purpose, it's explaining the chief purpose.
Okay, so by that logic then, why isn't giving legislative power to an executive agency also part of explaining how it's going to quote unquote work?
Well, I think what we're trying to do is articulate on a level that the voter will understand. And while I agree with your earlier premise that it is unusual for these types of grants of regulatory authority, constitutional grants of regulatory authority, the premise is that the legislature is not being responsive. The power of the people to amend their own constitution to go around the legislature in those circumstances where they're not being responsive and directly amend their constitution is sacrosanct. It's in Article 1 under the Declaration of Rights. And to the extent that what we've set up, we've informed them, this is what we're doing, we're piggybacking off of the existing system. I think the ballot summary unequivocally complies with the precedents of this court and even the recent precedent in terms of talking about the material legal effects. Because while that is a legal effect, I would not agree that that is the material legal effect. The material legal effect that we're doing is decriminalizing marijuana for adult use in Florida.
So you don't think a pretty dramatic change from a separation of powers perspective is a material legal effect?
When we're talking about,
isn't that one of the most fundamental principles in the Constitution?
It's a fundamental principle, but where you're talking about the people of Florida amending their constitution in a narrow defined area, in this case, adult use of a substance that was otherwise deemed criminal, I don't think that is a broad sweeping change and rebalancing of the separation of powers.
Does the amendment require new medical marijuana treatment centers? Does it require the department to authorize new distribution facilities?
It does not. We were familiar with the ongoing litigation that the court will hear argument on later this evening. And there were choices that were made to piggyback off of the existing structure without trying to put our finger on one side of the scale or the other on how that would work. So all of that will be left to the department and ultimately this court to determine how medical marijuana treatment centers and what constitutes a medical marijuana treatment center and what they can engage in. All of that will be left to the determination of the court.
So it simply permits medical marijuana treatment centers that are licensed pursuant to the existing constitutional provision to sell without restriction of the medical use, to sell for any purpose. Is that correct?
Correct. I believe the way those medical marijuana treatment centers can work under the current statute, a medical marijuana treatment center can provide an amount greater than what for medical use than what would be permitted for adult use. Right now, adult use is limited to 2.5 ounces. And the medical marijuana statute will be before the court, the legislature has expanded the ability to provide that in a medical context. The restrictions in Chapter 386 relate to a 70-day supply, which would be twice that amount, 2.5 ounces being a 35-day supply. So at least in this context, what is being provided is a much more limited for adult use. If you were talking about the overlap of the two, medical marijuana and adult marijuana, really what you're talking about is Venn diagrams with a significant amount of overlap, but there are going to be some differences on one and on the other.
You agree, though, that under the plain language of the amendment, once the legislature designates and licenses something as a medical marijuana treatment center, the regulations and/or state law could not prohibit the medical marijuana treatment center from also selling recreational marijuana.
Correct. The term that we use in the amendment is adult use for any reason. The term recreational itself might be limited. We didn't want a situation where a person wants to self-medicate on a simple isolated occasion, to be able to not obtain that same substance because they were buying it for medical reasons versus recreational reasons.
So the legislature couldn't, so if I've got to drive past 10 medical marijuana centers on my way to work, and the legislature thought, you know what, why don't we just have one of those be authorized to sell recreational marijuana? That would not be a policy choice that the legislature and or the Department of Health could have. It's all or nothing. Obviously subject to the limits on the amount, but if I'm a medical marijuana treatment center, then I'm by definition also a recreational marijuana sales center.
You could be if I believe that the point that you're getting at, I believe a medical marijuana treatment center could not be prohibited, that is authorized under Article 10, Section 29, could not be prohibited from making those sales for recreational or adult use. However, they could not be, on the same hand, there's nothing in the amendment that requires them to make those sales.
As to the medical marijuana treatment center, why is it important that the ballot summary disclose immunity for criminal and civil liability with them?
Why is, I apologize, Justice Polston, is the question, why is it important that it?
Your opponent argues that it's a material omission for the ballot summary not to include the immunity provided to the medical marijuana treatment centers. Why isn't it?
Well, first of all, I believe I disagree with the Drug-Free Americas and their related parties. I disagree with their interpretation of the amendment. What the amendment does is it grants, the immunity that is granted is immunity from criminal prosecution and civil liability for the penalties. Not every penalty that can be imposed on somebody is necessarily a criminal sanction. There are civil sanctions that can be imposed.
Do you not think that the amendment provides immunity from a tort claim if the medical treatment center, for example, provides some type of product that injures the person using the medical marijuana or the marijuana, recreational marijuana bought by the adult?
I do not. The text of the amendment itself incorporates limitations that apply to medical marijuana. So the same limitations that prohibit the use of marijuana while operating a boat or a car or a train or a plane. The same limitations that make it clear that this doesn't immunize violations of federal law, and the same limitations that indicate that the section shall not repeal or affect laws relating to negligence or professional malpractice. All of those same disclosures apply in this particular amendment as well. We wanted to make clear that we were not doing anything to dramatically upset the current status in terms of use beyond removing the restriction that an adult could only obtain marijuana for medical reasons. That's the restriction that we're trying to remove. And that's the restriction that the amendment removes.
In the text, it refers to sanctions under Florida law that there's immunity for. What does that refer to? In the context of, I know some cities and some counties have moved to civil sanctions at some point in time versus criminal sanctions for possession of marijuana or use of marijuana. So I think the sanctions that we're talking about are those types of civil penalties that may be imposed that don't rise to the criminal level. The Department of Health would have regulatory authority over these treatment centers, right?
Yes, they would.
So under typical administrative law, if they're not in compliance or they violated in some way, the department imposes sanctions typically in some administrative format. Is that exempt?
No, I believe that authority to regulate is separate. It doesn't immunize or otherwise change the nature of that regulatory authority. Just like amendment the Article 10, Section 29 doesn't either.
if the immunity provided in this particular paragraph was not restricted, as you argued, and the sanctions were more broadly exempted or immune than your argument, would that be material and something that should be included in the ballot summary?
I believe if that were the proper interpretation, if the amendment does something different than what I just said, then yes, I think that would probably need to be disclosed. However, here, it doesn't do what Drug-Free America says. The ability for a medical marijuana treatment center to provide marijuana is still going to be subject under the terms of the regulations. It's got to be consistent with this amendment, and that would include the regulations that are effectively adopted by the Department of Health to regulate those entities.
Thank you.
Now, I know one of the central arguments that we haven't really discussed is whether this amendment itself somehow misleads the voters by using the term permit and indicating that a voter may be able to use marijuana in Florida, and that's misleading because it would still be a violation of federal law. In this instance, we inform the voter in our ballot summary of the only organic law that we can change. We let them know the changes that we're making to the Florida Constitution. A constitutional amendment to the Florida Constitution cannot amend the US Constitution. It cannot amend federal statute. It only applies here. And under the longstanding precedents of this court has never found an affirmative obligation to inform a voter of what is going on with federal law, either the status of federal law or the effect.
I'm sorry to interrupt you on that. And I think your argument on that has some force, but I also thought that the way counsel for the chamber kind of brought it down to the sort of real world context of if you told someone, you know, you are permitted to use this marijuana, I mean, it seems like there's force to the argument that that's just not true, absent some sort of qualifier of, you know, you're permitted under state law, but it's not permitted under federal law. So what's wrong with the way that he boiled it down?
First, I would posit that if I'm giving legal advice to anybody about any activity, regardless of whether it is, I'm not going to be limited to 75 words. And if it was a requirement of this court to include what law applies or what law is being changed as a result of the amendment, then every amendment must say on its face applies only to Florida law or something to that extent.
Well, but most proposed constitutional amendments aren't authorizing something that's blatantly illegal under federal law. And as far as the 75-word thing goes, I mean, in this ballot summary, it seems to me the last sentence here, I mean, I haven't counted the words, but I mean, you've got an entire final sentence that's completely meaningless. It has zero, it communicates no information that a voter would have any idea what to make of that sentence. And so in your particular case, the omission of the federal law thing doesn't have anything to do with the word limit.
Well, in this case, I think the sentence, to the extent that a voter is looking to understand how is this actually going to change, it's at least putting them on notice that related to that chief purpose, they're going to have to do a little bit additional research to understand what circumstances are still going to apply that would be carried over from the medical context. So I would at least respectfully disagree that the language is surplusage. But certainly based upon the precedents of this court, we're changing the only constitution that we can change. The only law that we can change is Florida law. And this, again, this court has never, ever required someone to inform. So if you go back to the political term limits opinion, in that opinion, it was clear to Justice Overton that what the voters were voting on would not be given full effect because of the provisions of the U.S. Constitution governing the electors of the elections of representatives and senators. So at least in that context, the court was more than willing to say, you know what, we're still going to let the ballot go forward. It's not clearly and conclusively defective. And ultimately, at the end of the day, when we're talking about the application of that, a court will decide whether those provisions are enforceable or not. But at least in terms of the right of the people to amend their constitution in a way that is not consonant with federal law, that right is there, and I think it should be respected. There are provisions in our Constitution now that exist that are not consonant with federal law. One of them would be the marriage amendment that defines marriages between a man and a woman. That has, based upon recent U.S. Supreme Court precedent, they've overturned that in the Obergefell decision. And so that amendment that's currently in our Constitution is not consonant with federal law. So to the point, I think our summary accurately describes the changes it can make to Florida law. We've never been obligated to change federal law or to inform of the changes to federal law. And I know as a preliminary matter, the Senate has presented arguments related to the court should dismiss this and have the Secretary and the Attorney General start over once the next presidential election occurs. Nothing in the triggering mechanisms for the petition initiative process look forward to the election where the ballot will appear on the ballot, where the ballot will appear. They always look back at the last presidential election that occurred. If one were to accept the Senate's position, essentially what that means is when you hit February 1st of an election year, all of the process really probably stops because you're not going to know what that number is in that presidential election year until the presidential election occurs. That's contrary to the plain text of the Constitution. Additionally, although the Senate didn't get into it too deeply, the arguments that Chapter 2020-15 should be applied retroactively to this proceeding are incorrect. As a prefatory matter, it's unclear from the text of the statute whether 2020-15 should be applied to currently pending proceedings. There's nothing in the statute that affirmatively requires the Secretary of State to go back and recertify her numbers, and there's nothing that requires the Attorney General to repetition this court. And they haven't done so. So on that basis, in the absence of clear legislative intent, the law should not be applied retroactively. If the court believes that there is some sort of intent, the law should not be applied retroactively because it changes the rules. And in those circumstances where the retroactive application would either impair existing rights or add new legal consequences, then the court should not apply the law retroactively. And that's effectively what 2020-15 does. It creates a new legal consequence. It requires a new standard that this petition initiative must meet, and it applies a new standard of review related to the facial review under the United States Constitution. So for those reasons, it should not be applied retroactively. But if the court were to apply it retroactively, there's a problem with applying the facial review under the United States Constitution. And that problem is the legislature doesn't have the authority to substantively limit the right of the people to amend their Constitution. Article 10 or Article 11, Section 3 provides the only substantive limitation, that being it needs to relate to one single subject.
So do you accept it seems like the Senate's premise is that we can't treat this as a true advisory opinion, that if we say that it's facially unconstitutional, then that means it can't go on the ballot. I mean, do you accept that, or is there sort of a middle ground that we could, for purposes of that, since it would arguably be adding a new substantive limitation, we could just give our 2 cents and the voters can, know what our 2 cents are, and then they can vote however they want.
I think the problem that I would have is if the court were to take that type of approach, they would need to recede from some of their prior opinions. So if you look at Ray versus Mortham, in that opinion, the court recognized these advisory opinions that we're talking about, they're not like other advisory opinions that are issued. They have an effect. In this case, where the advisory is negative, it has the effect of removing the provision from the ballot.
Well, but I think the issue though would be that our cases don't address kind of an extra constitutional limitation like this one arguably is.
I think if the court were to just issue what is truly an advisory opinion and allow these provisions to continue to go onto the ballot, that might be an interesting dynamic. I'm certainly not arguing for that here. But at the end of the day, we do want to see this provision on the ballot. I think as a practical matter, the court's review is limited to what I would argue are the procedural authority given to the Attorney General to bring and the procedural machinations around that, and whether the amendment complies with those procedural requirements and the single subject requirement. And I think that would cabin the court's review. So this additional thing that the legislature is trying to give to the court, I think is probably outside the purview under the current constitutional framework.
Okay, and just to be clear, I'm not suggesting that this amendment would fail the federal constitutional test anyway. I'm just trying to kind of understand what sensible ways of dealing with this issue of what we should do with this new requirement that we have.
Sure. And I think if in the interest of judicial economy, I think the arguments that I presented preceding getting to that sort of more nuclear option are all options that would be available to the court to avoid reaching that constitutional question. The ballot title and summary in this case clearly and unambiguously and in neutral terms informs and explains the chief purpose of the amendment. The amendment itself is limited to only amending the Florida Constitution, and it creates restrictions aimed to the purpose of decriminalizing adult use of marijuana in a certain limited framework. Based upon that, we believe the court should validate the amendment, find that it complies with the provisions of Section 101.161 and Article 11, Section 3, and give a favorable advisory opinion and permit the amendment 1911 to go on the ballot. Thank you. Thank you for your time in making this available.
Thank you, counsel. We will now go to rebuttal.
Thank you, Mr. Chief Justice. I have 3 points that I'd like to make in rebuttal. First, there was a colloquy between the court and distinguished opposing counsel about the materiality of the problem with the ballot language that we've identified. And I'd like to briefly explain why, as a practical matter, we think that this could make a really big difference to voters. It could make a difference in 2 ways. One, in terms of the voters' assessment of whether they want this kind of initiative to be the policy of the state as a substantive matter. But there's another thing, and that is that it could also influence the voters' determination of whether this is the kind of policy that ought to be embodied in the text of the state constitution. And if a voter knows that the real world practical impact of adopting is that everything that the initiative purports to permit would actually still remain a crime under federal criminal law, that might affect not only the assessment of substantive policy, but also the assessment of whether it's worth going to the trouble of incorporating this provision in our fundamental law. Second, I'd like to talk briefly about why they didn't put that ballot summary that they put for the court's attention to the 2003.
Chief, I think Mr. LEVESQUE has his mic on, and I'm unable to hear it.
It has been muted.
Okay.
Well, it was unmuted. Counsel for the proponent, you need to stay on mute. Thank you.
Counsel,
Mr. General.
Since you have so little time left, you teased this issue on page 5 of your supplemental brief about the appropriate remedy when a proposed amendment is facially invalid. But then you didn't follow up on that later. What's your view on that?
Your Honor, we think that the enactment of Chapter 2020-15 raises potentially a very large number of thorny questions, both of statutory interpretation and potentially of constitutional interpretation, and that the Office of the Attorney General has elected not to pass on all those ancillary issues because we think that the narrower and easier way to dispose of this case is on the basis of the ballot language argument. I don't think it would be appropriate for me to formulate a position for the first time in oral argument on those delicate questions of statutory and constitutional interpretation. But we appreciate the court's interest in those issues. We hope that we can be of assistance to you in dealing with them in the future.
Thanks.
I see that I'm over my time, Mr. Chief Justice. I don't need to make the other points that I was planning on making with rebuttal, but I'm happy to answer any other questions that your honors might have.
I do have one question, if you'll allow me, Chief, and that is that assume that there's language in our case law that says that the court's going to presume that the average voter has a certain amount of common understanding and knowledge, and assume that we believe that applies to the federal law limitations on the use of marijuana, that people are just going to know that, so that there's no requirement to disclose the federal law implications. With that assumption, do you believe that so you set federal law aside, that the proposed amendment as written clearly and unambiguously describes the Florida law effect? Would you concede that?
Yes, Your Honor, we have not argued that other than the affirmatively misleading problem to which Your Honor refers, that the ballot summary is otherwise defective. We haven't advanced any such argument to the court.
Thank
you. I'm just curious, I mean, do you think that it's sufficient in a ballot summary to have a defined technical term like medical marijuana treatment center, and that sort of a reference is enough to put the voter on notice as to what all the, everything that goes along with that?
Your Honor, I don't want to evade the question, but again, I would be reluctant to formulate a position on that issue for the first time at oral argument. It's an issue that we didn't address in our brief, and I don't think it would be fair to the other parties to the litigation for me to formulate such a position now for the first time.
Thank you. We'll now go with further rebuttal.
Thank you, Your Honor. I just want to make a couple of quick points. One, Mr. Levesque kept referring to this, the application of the statute into this matter as retroactive. We don't believe it's retroactive. This matter is pending. We're not asking the court to go back and reevaluate in a case where it already has issued an opinion. We don't think it impairs existing rights. The petition is brought by the Attorney General. It's not brought by the party. The party can't waive this. This matter is to protect the ballot and to protect the Constitution. It is not to be exclusively for the benefit of the parties. These things are standardized so the parties can know what's going on. The sponsors can know what's going on, but it is not purely for their benefit that we go through this process. And I just want to say on the matter of, looking to federal law, that the sponsors made three arguments, essentially. One, the voters are going to understand the conflicts between federal law and state law. Two, that we need to do everything that's in this amendment in order to follow through on their logical oneness and purpose. To obtain that logical oneness and purpose, we need to have all these component pieces. And three, not all the pieces are necessarily preempted by federal law, and we'll need future litigation in the future to sort all that out. I would suggest, Your Honor, if we can't tell right now what is and what isn't conflicting with federal law, that if we're going to need future litigation, not all three of those things can be true. We cannot expect the voters to know all that. We cannot say parts of this can get struck down and parts of it can't, and it's all one single subject. And we cannot also then say, well, and we may have to work out later on in subsequent litigation what is and what isn't feasible. I do not think all three of those things can be true at the same time, Your Honor.
All right, counsel. We thank you, and we thank all the other participants in this argument for your arguments, and we will now move to our next case. Thank you.